Howdy, and welcome to Chapter 3. In Chapter 3, we're going to talk about some of the laws governing human resource management. As managers, we need to understand the legal issues that affect the practice of human resource management because so many things we do in HR are constrained by these laws. In fact, anything you do in HR, when you think about hiring, compensation, benefits, appraisal, termination, unions, etc. So it's really important that as HR practitioners we have a pretty good understanding of how these laws work. Also, you as an employee need to understand how these laws work. You need to know the laws. You can protect yourself. You can know when you're being discriminated against, you're not paid correctly, and things like that. And also, these laws are extremely complex and changing. New laws are coming into play every day. Courts are making decisions. So it's important that we understand the nature of these laws. You should have had a lot of this material in a previous class. So this just should be an overview or a review for you. And then as we talk about each functional area, we'll revisit the laws that apply to that area. So I hope you enjoy this chapter. The learning objectives for this chapter are as follows. First, I'd like to talk about why this is so important. First of all, it's just the right thing to do. All companies should follow the laws. It helps to understand the limitations of HR and legal departments. Okay. It facilitates a fair and humane environment. It can limit potential liability. It can avoid a negative image for the company. And most importantly, it affects competitive advantage. And also, the final reason is because laws, in fact, EEO laws, are dynamic and complex. And we need to understand these laws. So we're going to talk about each law very briefly. You should already have learned these laws in your law class, so this should be just sort of a review for you. So the Equal Pay Act of 1963 says that male and female workers should receive equal pay for work requiring equal skill, effort, and responsibility under similar working conditions. And this definition is very important because it's very difficult to say what is equal pay, equal skill, and so on. And so that's the big challenge, determining whether two employees are in fact doing the same job. Okay, oops. Okay, it's very difficult to determine that because there are so many differences. And then the law provided for many exceptions. Okay, So the exceptions are due to merit pay. In other words, if a male is doing a better job, they're entitled to a higher percentage of merit pay than a female. If they're producing better work, quality or quantity of work, they're entitled to more pay. Okay, quality or quantity of work. Some seniority plans, this is mainly in a union environment, may specify based on seniority people get paid more, or geographic regions. In other words, I can pay someone more due to cost of living in New York versus, let's say, Texas. And lastly, just any factor other than gender can be an exception. The main law affecting human resources is the Civil Rights Act of 1964, Title VII. This prohibits discrimination based upon race, color, religion, sex, national origin. Many amendments were made later to add different classes, but this is what the original law, when it was passed, said. It's based on the legal theory of protected class, meaning that this group of people suffered such horrible discrimination that they will now be protected by the judicial system. Because before this, there was open and explicit discrimination based on race. And this law covers African Americans, Asian Americans, Latinos, Native Americans, and women. It served to create the Equal Opportunity Commission. Okay. And this is a picture of the act being signed, and you can see Martin Luther King is right there, okay, and President Johnson is signing the bill. That's kind of interesting trivia. So it's set up two illegal types of discrimination. I talk about discrimination. Discrimination simply means making distinctions, but in an HR sense, it means making distinctions among people. And Title VII says we can't make these decisions based on race, color, religion, sex, or national origin. So there are two types of discrimination. The first is disparate treatment or intentional, meaning that an employer intentionally discriminates against someone because they're a woman, because they're black, because they're Asian. Okay, disparate impact, we also call adverse impact, is where a standard is applied equally to everyone, but it has a negative effect on someone in a protected class. So it's a little less obvious than disparate treatment. So this is an example of disparate impact. It says for a fair selection, everybody has to take the same exam, climb that tree. So I'm applying a standard equally to everybody, but it's adversely going to affect probably the fish, probably quite a bit. So you can see how that would be. And kind of a silly example, but applied to real life, if I had a requirement that for this particular job you had to be 6 foot tall, that would be applied evenly to everybody, but it would exclude many women, some minorities. You can kind of get that idea. So some major cases happened. We're just going to talk about a couple of them. You should have talked about these earlier. The first being McDonnell Douglas versus Green. And this established the precedent for how a prima facie case of intentional discrimination is established. Prima facie is just Latin for on its face. So it means that if someone meets these requirements, it indicates discrimination on its face may have occurred, but now the employer has to explain what happened. So this says that discrimination may have occurred if the plaintiff can show 4 different things. That they belong to the protected group, in other words, they're, let's say, a woman, that they applied for and they're qualified for the job. Let's say this woman applied to be an accountant and has a CPA and a master's degree in accounting. They were rejected. The woman was not hired. After rejection, the position remained open or was filled by someone who was not a member of the protected group. So in other words, the woman's rejected and the position either remains open or a man was hired. So if someone shows those four requirements, then it's up to the company to prove what was happening. And it's not so obvious in the case of disparate impact. In two major cases that occurred in this area, the first was Griggs versus Duke Power, and Duke Power came up with a requirement that coal handlers be high school graduates, and this impacted the protected class of black employees adversely because most of them did not have a high school diploma. The Supreme Court ruled that even though these were applied equally to all employees, it was discriminatory because it adversely impacted the protected class. Secondly, Duke Power was unable to show that the standards were related to job performance. So in other words, they couldn't prove that having a high school degree made someone a really great coal handler. Okay, so that was an important case for adverse impact. So an employer has to prove that. Albemarle Paper Company versus Moody reinforced Griggs versus Duke Power, but expanded upon it and talks about tests that are used. And said tests have to be validated, statistically validated, and proves that they actually predict great performance. Okay, is what happened. So, so if an employer uses this test, then it has to be analyzed, documented. The standards have to be clear and unambiguous, and it has to be a valid predictor of job performance, and the employer has to prove that. So what can an employer do after a plaintiff establishes a case of possible discrimination? Okay, an employer has to defend this, and it's different based upon whether it's intentional or whether it's adverse impact. So in the case of an intentional discrimination, the burden is on the employer once the prima facie case is established. So the employer has to come up with a reason why, for instance, it eliminated or discriminated against a whole complete group of people. The main defense in this, but although it's kind of rare to have, is called a BFOQ, or bona fide occupational qualification. Okay, so an employer would have to prove that this BOQ is a business necessity. Okay, that they have to have this in order to be in business or be competitive business, part of their business. So they can have several defenses. One is called all or nearly all, meaning that all or nearly all of a group are incapable of performing a job. Okay, like for instance, if I were to say that police officers have to have the ability to lift 100 pounds, okay, and that eliminated women, I would have to prove that that's a business necessity, okay, that they can't be successful in the job without it. Okay, the second one is authenticity, and we see this quite a bit in BFOQs. This could apply to models, to actors, could be restaurant workers. If I have a Mexican restaurant and want it to look authentic, I'll hire Mexican people. Could be a church. A Catholic church will not hire a Baptist minister. They would hire a priest. That'd be an authenticity. Propriety is also a reason for a BFOQ. And this one, for instance, applies to perhaps prison guards. I wouldn't want a female prison guard in an all-male prison, or I wouldn't want a male handing out towels in a female locker room at the gym. It'd be propriety. Safety is the last category. For safety, perhaps I know that pilots, once they reach the age of 60, can't fly commercial flights. So that could be a BFOQ based upon age, based upon safety. Okay, so that's the main reason in intentional. For unintentional, we can look at, one way to defend that is to look at hiring rates. And this is called the 4/5 rule, where 4/5 is the same as 80%. That becomes important. So what we want to do, we want to look at the rate in which we're hiring people from the minority group versus the other group. Okay, and we establish a prima facie case if the hiring group or the former group is less than 4/5 of the latter group. So what that means, and here's a great example. Let's say I have a job opening and I have 100 white applicants, 50 black applicants. I hire 52 of the white applicants and 14 of the black applicants. So in essence, I've hired 52% of the white people who applied and 28% of the black people that applied. So then what I do is I divide these percentages and come up with a percentage. So it's 53.8. So I've hired 53.8% is the difference between the hiring rate of the two groups. And then I look at that and say, is this less than 4/5 or 80%? If it is, it indicates adverse impact could have happened. Doesn't mean it did. It says that something may have occurred to cause adverse impact. Then the employer has to demonstrate that the practice in question is a business necessity, is what would happen after that. Okay, sexual harassment, honest definition, is just harassment on the basis of sex. Was added to Title VII as part of gender discrimination. If we look at the definition, it's important that it substantially interferes with a person's work performance or the creation of an intimidating, hostile work environment. Okay, and companies have to provide an environment that is free of sexual harassment. So two types of sexual harassment. One is quid pro quo. This is something that has tangible economic consequences for someone. And quid pro quo just means this for that. So in other words, if someone tells their secretary that if you go with me to New Orleans this weekend, I'll make sure you get that promotion, or if you don't go, I'm going to have to lay you off. That would be based upon tangible and economic consequences. The other type is called hostile work environment. Okay, and this can be by supervisors or non-supervisors can create a hostile work environment. So a hostile work environment doesn't have to result in tangible loss or economic consequence. It's something that interferes with an employee's performance. It creates an intimidating, humiliating kind of environment. It affects somebody's emotional and psychological well-being. So to be considered a hostile environment, 3 conditions must be met. 1, it must be sexual in nature. 2nd, it must be severe or pervasive. And 3rd, it has to be unwelcome. So it has to be sexual in nature. It has to be severe or pervasive. It can't just be a one-time joke that occurred. It has to be something that maybe happened one time, but it was really severe or serious. Pervasive would be something less than severe, but it's happening all the time. Happens a lot. The employee also has to find this unwelcome. Okay, they don't like it. It interferes with their performance on the job. Some other laws that are important. Pregnancy Discrimination Act of 1978 prohibits discrimination based on pregnancy or pregnancy-related medical conditions. Okay, it says that an employer is prohibited from sex discrimination based on pregnancy, childbirth, or related medical conditions, and an employer has to treat pregnancy and childbirth like any other medical condition, and that comes into play oftentimes in the benefit plans. The second one is the Age Discrimination and Employment Act of 1967, which covers people over the age of 40 years of employment. This has become pretty big in the workplace because as the workplace is aging, more and more problems and claims are coming of this. The Civil Rights Act of 1991 now allowed employees to sue for compensatory and punitive damages. So it put a lot of teeth in the Civil Rights Act as far as penalties for employers. It also said that plaintiffs have the right to a jury trial, which allowed them to get more in rewards. A major law that came into effect in 1990 is Americans with Disabilities Act, or ADA. ADA forbids employment discrimination against people with disabilities who are able to perform the essential functions of the job with or without reasonable accommodation. So an individual with disabilities, a person with a physical or mental impairment, substantially affects one or more major life activities. Okay, so it's very inclusive of a lot of conditions. It says they have to be able to perform the essential functions of the job. These are duties that they have to do to be an effective employee. Okay. It says that they have to do this with or without reasonable accommodation, meaning that the employer, if it's not an undue hardship, needs to provide accommodation. And these are very simple things such as adjusting an employee's workstation, their computer, their chair, the noise level, the lighting, or allowing employees to have intermittent time off or time off during the day. Okay. Affirmative action is provided through Executive Order 11246, and this makes it mandatory for government contractors and subcontractors to have a plan to make sure their workforce is representative of the general population in terms of gender and minority. So what happened after the Civil Rights Act was passed, it was very difficult to go from total discrimination to now we don't have discrimination. So Executive Order 11246 was passed by President Johnson in order to make this an even playing field or give some advantage to those people who were so discriminated against for so long. So it requires companies to look at their workforce and determine whether they're underutilized in protected groups. And if they are, then they have to have a plan on how they're going to fix that. They have to have goals, timetables, action steps, and that sort of thing. The agencies that handle these laws, there are two of them. The first is the Office of Federal Contract Compliance Programs, or OFCCP. They handle the affirmative action plans, okay? And they deal with federal contractors, and most employees in essence are a federal contractor or subcontractor. If you sell something to the government or sell something to someone who sells something to the government, you're covered here. Then the Equal Employment Opportunity Commission, or EEOC, investigates discrimination complaints. They may take legal action against employers based upon investigations. So the EEOC, how that works is, let's say somebody feels that they weren't hired due to their, let's say, race. They would go and file a claim with the EEOC. They would accept the claim. They would inform the employer, hey, a claim's been filed by so-and-so for this. An investigation would happen where the employer would be asked for all kinds of information. They may have to do the 4/5 rule testing, amongst other things. They would have to turn over their applicant pool and whatever information was requested. The EEOC would make a determination. If they determine no discrimination, it would obviously end there. They determine that, well, something doesn't look right, perhaps something happened. Then they would do conciliation. They would get with the employer and the person and try to resolve it. If it can't be resolved, they would issue a notice of right to sue to the person complaining. And that means now the person has the right to go into civil court and sue that employer if they so want to. A major law that came out in 1970 is the Occupational Safety and Health Act, which set up the Occupational Safety and Health Administration. And this is the agency of the government that's responsible for all the safety stuff in the workplace. So they inspect employers, they apply the safety and health standards, they fine employers. They have a lot of power when it comes to the workplace. So each employer has a general duty to furnish an employee a place free from hazard. This is called the General Duty Clause. Okay, so in general, employers must provide a safe workplace. It totally makes sense. Employers have to keep records of work-related injuries and illnesses, and they have to post this once a year so employees can see that. Employees have the right to request an inspection, to know what dangerous substances are in their workplace. They have the right to be informed about exposure to hazards, okay, and have employer violations posted so they know kind of what's going on in the workplace. As we said, OSHA is responsible for inspecting and applying the fines and all that. So OSHA will come out and inspect an employer if there's imminent danger. They'll come out, and they don't have to tell an employer they're coming. They just kind of show up, and they're allowed to come into the facility. If they think there's imminent danger, something bad's about to happen, they're going to come immediately. So that's first level. Second level is where something has happened, where somebody, there's been a fatality, someone dies in the workplace, or there's an accident involving hospitalization of 5 or more workers, they'll come and investigate. Third level is where an employee complains. Okay, they'll come out, but not as important as the previous two. Fourth level is called high hazard industries, and these are industries deemed by OSHA to be high hazard. It could be, let's say, the mining industry or the longshoring industry, where they'll just come out and inspect just because of the nature of what goes on in that industry. This concludes the video for Chapter 3. As you could see from the chapter, there are a lot of laws that impact human resource management. And we'll talk about those laws as we go through each chapter. Thank you.